All right, Nigerians, this Tinubu FBI records controversy is refusing to die. And now the allegations are becoming even more serious because Atiku's U.S. lobbying firm is claiming President Bola Tinubu has spent millions of dollars trying to keep these records away from the public. That is a very serious allegation and it deserves a serious response. According to von Batten-Montague-York, the Washington-based firm working for Atiku Abubakar, Tinubu cannot on one hand say he is not trying to block the release of the records and on the other hand have his legal team joining requests before the U.S. court for more time while also engaging the FBI and DEA in the same legal fight. Their argument is simple. If you truly have nothing to hide, why are you fighting so hard to keep parts of the file from coming out? That question is going to resonate with a lot of Nigerians because this case is no longer just about a civil forfeiture matter from the 1990s. There is now an active freedom of information battle involving the U.S. Department of Justice, the FBI and the DEA, and the FBI itself has said some of the information is sensitive enough that releasing it could endanger lives and expose investigative methods. So naturally, Nigerians are asking what exactly is inside those records. And now the U.S. lobbying firm is adding another layer by alleging that Tinubu has spent millions of dollars in this effort. If that allegation is true, then Nigerians deserve to know exactly what was spent, who was paid, from what source, and for what legal or lobbying work. Was it private money? Was it campaign money? Was it public money? Those distinctions matter. Because if the president is using his personal funds to defend himself in a legal matter, that is one thing. If Nigerian public money is involved in any way, that becomes a much bigger accountability issue. And this is exactly the kind of detail that should not be buried. But let us also be careful with one point. From Batten-Montague-York is Atiku's lobbying firm. Atiku is contesting against Tinubu in 2027. So this firm is not coming into this story as a neutral academic institution. It has a political client. That does not automatically make its allegations false, but it means the allegation that millions of dollars were spent should be backed with documents, invoices, court filings, lobbying disclosures, or some other hard evidence. Because if you make that kind of claim against a sitting president, show Nigerians the receipts. Do not just throw the number out because it sounds damaging. Now, the firm also argues that Tinubu's old explanation that this was merely a civil case no longer answers the bigger question because U.S. law enforcement agencies are actively fighting over investigative records. And frankly, this is where Tinubu's camp has a problem. Yes, the old case was a civil forfeiture proceeding. Yes, that is different from a criminal conviction. But Nigerians have moved beyond that narrow argument. The question now is not simply whether Tinubu was ever criminally convicted. The question is what the FBI, DEA, and DOJ actually have in their historical records, and why some of that information is considered sensitive more than 3 decades later. That is what people want to know. And every time there is another attempt to delay, seal, redact, or withhold information, suspicion grows. Now we have another perspective from Aloy Ejimako, who is Nnamdi Kanu's special counsel. His analysis is actually more legal and less political. He says he expects Tinubu's records to eventually be disclosed, but that important parts may be redacted. And that prediction makes sense based on the legal arguments already before the court. He points specifically to US FOIA Exemption 7F, which allows law enforcement agencies to withhold records where release could reasonably be expected to endanger the life or physical safety of an individual. In simple English, the FBI does not have to prove somebody will definitely be killed. It only has to show there is a reasonable expectation of danger. Ejimako then lists possible reasons the FBI may be invoking that protection. The records may contain the identities of confidential informants. They may contain cooperating witnesses. They may contain third parties linked to the old investigation. They may contain names of law enforcement officers. They may contain operational details that could still expose people or their families to retaliation. And remember, even though the investigation itself is decades old, people connected to that investigation may still be alive. Some networks may still exist. Some relatives may still be vulnerable. So the idea that old records can still create danger is not impossible. But here is where the issue gets politically explosive. If the most sensitive parts are redacted, what exactly will Nigerians eventually see? Will the public get enough information to understand what happened? Or will the released documents contain mostly harmless details while the most important portions remain blacked out? Ejimako predicts the latter. He says the public may eventually get documents, but the politically important parts may remain hidden. That would create a very frustrating outcome, because Tinubu's opponents will say the truth is inside the redactions. Tinubu's supporters will say nothing damaging was released, and Nigerians will still be arguing. This is why transparency matters so much. If the court determines that some parts must genuinely remain secret to protect lives, fine. But the government should not be allowed to hide more than the law strictly requires. Every releasable page should be released. Every releasable sentence should be released. Redactions should be narrow. Because there is a public interest here, Tinubu is not a private businessman anymore. He is president of Nigeria and is seeking another term. His history is therefore a legitimate matter of public scrutiny. And this is where I think many Nigerians will ask a very simple question. If there is truly nothing damaging in these records, why has this legal fight become so complicated that does not prove guilt? But it is a fair question. Now let us also look at Tinubu's decision to join the DOJ request for a 10-day extension. That is politically awkward. His defenders can say there are legitimate legal reasons for asking for more time. Maybe lawyers needed time to review records. Maybe there were privacy concerns. Maybe there were national security or safety implications. Fine. But politically, it feeds the opposition narrative that Tinubu is actively resisting disclosure. You cannot complain that people are suspicious while your legal team is in court supporting delay. If the president's position is that there is nothing to hide, then his legal strategy should be explained clearly. What exactly is he asking the court to protect? His personal privacy, third-party safety, investigative sources, law enforcement techniques? What? Give Nigerians a clear answer. Because vague legal resistance creates political damage. Now the allegation that Tinubu has spent millions of dollars also raises a broader issue about lobbying and foreign legal representation. Nigerian politicians have increasingly spent serious money trying to shape opinion in Washington. Atiku has his own U.S. lobbying firm. Tinubu's government and allies have also engaged American firms in different contexts. That tells you something about how important international perception has become in Nigerian politics. But Nigerians should ask whether politicians are spending huge sums abroad while ordinary citizens are struggling at home. If millions of dollars are being spent defending reputations in Washington, how does that compare with what is being spent on hospitals, schools, security, or even legal transparency at home? Again, the source of the money matters. Private money is private money. Public money is a different matter entirely. Now, let us talk about the FBI's request for private review. Judge Beryl Howell has allowed the agency to explain some of its reasoning privately. That does not mean the judge has accepted every FBI claim. It means the court is willing to examine the sensitive justification without making it public. And that is an important distinction. The FBI still has to convince the judge. The judge can reject some withholding. The judge can accept some. The judge can order partial disclosure. The judge can allow reductions. So this is not over. And this is why Atiku's firm should also avoid overreaching. They are saying the involvement of sensitive law enforcement material proves Tinubu's innocent explanation is false. That is too broad. Sensitive information can exist in many kinds of investigations without automatically proving the subject committed the crime being investigated. The stronger argument is simply this: there are records. They are serious enough to trigger FOIA exemptions. The public deserves every part that can legally be disclosed. That argument is enough. You do not need to exaggerate it. Now, Ejimako's prediction that the documents will be released but heavily redacted is probably the scenario Nigerians should prepare for. And if that happens, both sides will have to behave responsibly. Do not treat a redacted line as automatic proof of criminality. Do not treat a blank page as proof of innocence either. Redaction means the court or agency has decided that particular information cannot be publicly disclosed under the law. It does not by itself tell you what the hidden content proves. And this is where political propaganda will become dangerous. One blacked out paragraph will suddenly become proof of 10 different theories on social media. People will say informant, CIA asset, DEA asset, drug trafficker, protected witness, political deal, everything without seeing the content. That is not serious analysis. Now, at the same time, Tinubu's camp should understand that secrecy has consequences. If you want public confidence, transparency is always stronger than silence. If there are records that can clear up misconceptions, release them. If there are documents that show the context of the 1993 settlement, release them. If there are explanations for the money and the investigation, put them out. Do not rely only on saying there was no criminal conviction. That point is legally important, but politically it no longer answers everything people are asking. The public wants the fuller picture. And this is where Nigerians should keep the pressure on both sides. Atiku's camp says Tinubu spent millions to hide the files. Show the evidence. Tinubu's camp says there is nothing criminal to hide. Support transparency where possible. The FBI says disclosure could endanger lives. Prove that to the judge and limit withholding to what is absolutely necessary. That is how accountability works. Now, there is another important part of this story. Ejimako says sensitive records may identify informants, witnesses, officers, or other people connected to the old investigation. That possibility also explains why the idea of release everything immediately is too simplistic. Imagine a person secretly cooperated with law enforcement decades ago, and exposing that person today could lead to retaliation. The public interest in disclosure is real, but so is the responsibility to protect innocent people. The court has to balance both. That is why judicial oversight is important. And honestly, Nigeria should learn from that. Too often, in our own system, sensitive government records simply disappear behind the phrase national security. Nobody knows who reviewed the claim. Nobody knows whether the secrecy was justified. Nobody knows whether the information was actually sensitive or merely embarrassing. In this American case, at least a judge is being asked to look at the material and determine whether withholding is legitimate. Nigeria needs stronger systems like that. Now, politically, this matter is becoming dangerous for Tinubu because it will follow him directly into the 2027 campaign. Every new court filing will become opposition material. Every redaction will become a conspiracy theory. Every delay will become an accusation of cover-up. And if his legal team continues to resist disclosure without giving a strong public explanation, the suspicion will only grow. But Atiku also faces a credibility test. His team cannot make unsupported claims just because the political environment is favorable. If they say millions of dollars, prove it. If they say Tinubu is hiding specific records, identify what filing supports that claim. If they say the FBI's secrecy proves criminal wrongdoing, that is too far unless the documents eventually establish it, because overplaying the case could backfire. Now, I think this is where Nigerians themselves should decide what standard they want. Would you rather see every legally releasable document come out, even if large portions are blacked out, or do you think the whole matter has already become too politicized to produce clarity? Because whatever happens next, one thing is certain. This issue is not disappearing before 2027. Tinubu's opponents will keep pushing. His lawyers will keep defending. The FBI will keep protecting what it says is sensitive. And Judge Howell will keep deciding how much the public is entitled to see. The best outcome is not political victory for Atiku or Tinubu. The best outcome is maximum lawful transparency. If the records clear Tinubu, let Nigerians see that. If they raise serious questions, let him answer them. If certain details genuinely endanger people, protect those details. But do not hide the whole truth behind secrecy, and do not manufacture guilt from what remains hidden. That balance is difficult, but it is necessary. Because Nigerians are not asking for rumors anymore. They want documents. They want facts. They want explanations. And for a president seeking another 4 years, that level of scrutiny should not be treated as persecution. It comes with the office.